Thank you. Good afternoon, everybody. Ollie, good afternoon. Hello. Thank you for your loving poem. And recording that this is not a celebration but an accusation. As a man, I'm stepping forward to perhaps share a few thoughts about the first woman that challenged exclusion from legal practice. So, of course, we're here because on the 10th of April 1923, the all-male Parliament adopted a law which enabled women to enter legal practice. It's a strange law as statutes go. The first part of the law says that women should be able or are now able to be admitted as practicing attorneys, advocates, conveyancers, and so forth. But it's the second half of the law that's intriguing. It says that all existing laws should be interpreted accordingly. In other words, the change is brought about by Parliament enacting an interpretive mandate, instructing the courts to reinterpret the laws in a specific way. That made me think that it might have been possible to interpret the laws in this way even before this law was enacted. And indeed, if you go back into the history then, you find that 10 years or so before the law was passed, women challenged the exclusion from their ability to practice in the High Court in the Transvaal and in the Cape Colony as it was at that stage. So I think we should move away from the legislative moment that we celebrate into the case law for two reasons. First of all, it places the women in the center of our story, so we can start talking about these litigants that approach the courts, and it also places the court and the male judges in the limelight, and the legal culture that existed at that time, and that might, I think we could ask or suggest, still persists to today. So the legislation in a certain sense made the court orders against the admission of these women obsolete, but in a certain sense the legal culture remains and has survived. So that's where we're going. These women approached the court as a site of political struggle, as a site of transformation, and the courts disowned that space. We'll get to the reasoning of the courts. And my question is whether the courts today have changed or are still seen as not a site for political transformation and struggle as it perhaps could be. So going back to the women then, the first one is Sonia Schlesinger. She arrived in South Africa from Russia. She was born in Moscow in the early 1890s. And when Mahatma Gandhi opened his law practice in Johannesburg in 1903, he was looking for a personal assistant, and she joined the firm. She played a very prominent role during the next 10 years in that firm. It was a time when Gandhi developed the strategy of passive resistance and spent a lot of time in and out of prison fighting the registration laws at the time. And by all accounts, while he was in jail, she took care of the practice and ran the campaign in a certain sense. She visited people in jail, she managed the finances, she wrote public speeches very significantly in 1908. She drafted a speech that she wanted to read to a congregation of Indian women and men. Gandhi wouldn't allow it, and he read the speech on her behalf. But in the speech, she says, she refers to the suffragette movement in England and how women there are fighting the system, and urged the people locally to take courage from what the women are achieving in England, that the local men here should emulate in a certain sense. So a year after this, she became indentured as a clerk in Gandhi's firm. We signed the contract, and the other men working in the firm, but the Incorporated Law Society wouldn't accept the articles of clerkship. In those days, you had to do clerkship for 3 years and then you could be admitted. So no legal studies at the law faculty as today. So Sonia Schlesinger then approached the High Court to order the Incorporated Law Society to register articles of clerkship. A single judge, Judge Bristow, sat and declined the order. The law was a recent law. It was a law just after the South African War in 1902, so it was a British proclamation to re-establish a legal system in the war-torn colony, and basically said the High Court can admit as an attorney any person, provided that he served the articles of clerkship. But of course there was an interpretation act that said he means she, and the argument was that this is a new law, it's a fast industrializing era, it's post-war, things are changing, and that Sonia Schlesing qualifies obviously under the letter of the law being a person to be admitted as attorney. The court declined that in a very circular manner by saying the Act says every attorney can be admitted, or any person can be admitted as an attorney, and the term attorney has a very established meaning, and that's only open to men. So interpreting the word person in light of attorney, which is male only. But it's a separation of powers issue that it boils down to in the end. The judge is sitting here on my own as a single judge. I'm not going to bring about this substantive legal transformation. The correct route is for Sonia Schlesing to approach Parliament and to fight a legal campaign. Of course, the fact that she already referenced the suffragette movement highlighted the absurdity of this suggestion in a certain sense. It was an all-male parliament. Women did not have the right to vote at that time. They only acquired that in 1930 in South Africa, as you might know. So for the male judge to refer a minority group at that stage to Parliament, another male-dominated forum, seemed to have been a dead end. So after the dismissal of her claim, Sonia Schlesing kept on working in Gandhi's law firm until he eventually left the country in 1914. They remained in correspondence and contact, and she wrote to him that women can now be admitted. But she had gone on to study a BA at Wits University and became a teacher at Krugersdorp High School, where she taught Latin. So there's this connection, I think, with love of law and things law. So she taught Latin, and eventually, in 1955, when she was 65 years old, she enrolled for an LLB at the University of KwaZulu-Natal. She was ill at that stage, so she dropped out the next year, and she died the year after that. So her dream of practicing as a lawyer remained unfulfilled. The second character is Madeleine Hoekie, which brings us down to Vryburg and to the Cape. This is perhaps the more well-known case. So Madeleine registered also articles of clerkship in 1912, 3 years after Sonia Schlesing tried to do so. Again, the same story, the Incorporated Law Society wouldn't register. She approached the Cape High Court, and here the Judge President Marsdorp said yes, she can be admitted to practice law. So in her case, the argument was slightly more tricky because the law that regulated the admission to the profession dated back to 1834, so much longer than the one in the Transvaal. I think it's more difficult to deal with such a law in a certain sense, but Judge Marsdorp said this law, the prima facie meaning of the broad language, again, it speaks about any person can be admitted, would allow it to be admitted, unless there's a more specific law dating back to wherever that, creates an exception. So any person except, there's a specific law excluding women. And he went through the common law and he couldn't find such a specific law excluding women. There's an interesting part in the judgment where they take us back to Roman times and another woman that tried to enter the legal profession, Carfania as her name. And in the digest, there's reference to the reason why women can't practice law is because of the behavior of this woman, Carfania. She annoyed the powers to be, and they, as a result, banned women from practicing law. So that's the solid sand upon which the corpus is built, and the whole thing remained in place. So the Incorporated Law Societies obviously appealed to the appellate division, and in the appellate division the court overturned the judgment to say women cannot practice law. So Innes, the acting Chief Justice, did so by invoking this doctrine that the meaning of a statutory provision is fixed at the date that it is enacted. So in 12, when you interpret the statute, you have to give it the meaning that it had in 1834. The original intention of the drafters or the original meaning of the words in 1834. And going back on that presumption, or that assumption, he found that in 1834 the word term person did not include a female person, so on that basis, in 1912, Madeleine Hoekie could not enter the legal profession. Again, the meaning of the law is fixed, and if the law must be changed, it's not for the court to do so, it is for Parliament to do so. So separation of powers argument at the bottom of this as well. And also all three of the judges urging Madeleine Hoekie to approach Parliament to bring about legal reform. In a sense, in so many words, the result is harsh. It's a hard outcome. But in so many words, he said the court can't help at all. The court can't be of any assistance. So I don't know what happened to Madeleine Hoekie after that. I couldn't find information. Perhaps if you're interested in this for a research paper or something, you can take out the project. But I don't know what happened to her in any case. She ever practiced law, but of course 11 years later Parliament did enact this law, and here we are now celebrating that event. As I said, that event formally overtook the court orders because the courts, women can now be allowed. But that idea that the courts could have interpreted the provision, person, in a transformative way, the courts could have served as a site of struggle and change, remains for us to ask whether 100 years later that dominant culture that the court has owned that has been effectively disrupted by the presence of women, the change of the constitution, and so forth. I think people would say it's an open-ended question. How do you judge the judges going back? Because today you still hear courts say it's a separation of powers issue, legal transformation should be driven by the Parliament, should take the lead, and the court has a very limited role to play in this context. So it's not so clear-cut that this interpretive approach or argument would not hold water today. And I say this because Justice Sachs wrote the judgment, luckily he's on the right side of history. In Daniels there's a scandal. It's a constitutional court judgment in 2004, where the question was whether the term spouse in certain legislation includes only people married under the Marriage Act of 1961 officially, or whether it also includes people in monogamous Muslim marriages, so contracted in terms of Muslim rights but not registered under the Marriage Act. And Justice Sachs said, well, it's not interpretive gymnastics that's required of us here. All we need to do is to give the word spouse its ordinary meaning. And then the Muslim spouse, or would be recognized. And he refers in the footnote to exactly these cases, the Hoekie case and the Schlesinger cases, and say this is similar to those cases, but of course it's not, because what Justice Sachs did is exactly the opposite to what the courts did in those earlier cases. He is taking the lead, using the court as a transformative space to bring about legal transformation. But the story is not so simple, because there's a very strong minority judgment written by Deputy Chief Justice then, I think, or it was not yet, Moseneki, in which Justice Moseneki said we cannot reinterpret this term in the way Justice Alban Sachs is trying to do so. That goes against all the principles of statutory interpretation. It means that words are too broadly and too open-ended, and so from an interpretive perspective there's nothing we can do there. We can't help the Muslim women before the court. But of course times have changed, and so the court does have this battle power now to declare legislation unconstitutional. And that's what he suggested. The law must be declared unconstitutional, and the court could remedy the effect by reading words into the statute. But that's not an interpretive remedy. So just as a matter of interpretive culture, the interpretive culture that Justice Moseneki put in place is very similar to the interpretive culture that the justices followed in the original Schlesinger and Hoekie cases. Which leaves one to ponder the question again. How do we judge those judges from those days? Perhaps we should ask in light of your poem, how do we judge the judges sitting on the bench today? Thank you.